Namaste friends, welcome back to my channel. In this video, I will be talking about Vakalatnama. So the exact definition of Vakalatnama is provided under Section 2U of Advocates Welfare Fund Act 2001. So in common terms, a Vakalatnama is nothing but it is a legal document which authorizes an advocate to represent a client in a court of law. It also grants the lawyer the power to act on behalf of the client. Now let us understand what are the salient features of Vakalatnama. First one is legal representation. By signing the Vakalatnama, the client is authorizing the advocate to file petitions, to present the arguments, and also to attend all the hearings on his behalf. Secondly, obligation or extent of delegation. Since there is a client-lawyer relationship which is developed between them, this is going to be binding, and also the extent to which the advocate can function also depends upon the terms which are agreed between them. Thirdly, formal authorization and responsibilities. So here the client is actually giving the consent that the advocate can represent him. So that is formal authorization. And the responsibility of the advocate will include that he is handling all the legal matters related to the case. Like he can file the documents, he can cross-examine the witnesses, and also he can make submissions on behalf of the client. Thirdly, revocable anytime. So the client also has an option to revoke the Vakalatnama at any time during the case. But he has to get the NOC from the previous advocate, and also he has to make sure that he follows any legal processes which are involved in doing so. Next, let us look at what are the essentials of Vakalatnama. So the first one is name of the case or cases for which the advocate has been appointed. That has to be mentioned. Secondly, the date on which this Vakalatnama was executed has to be mentioned. Thirdly, name of the appearing court or courts in which the advocate will be representing this client has to be mentioned. Thirdly, name of the authorizing person. Fifth, the signature of the parties should be there. And sixth one, type of power which is granted to the advocate has to be mentioned. Seventh one, the complete address of the advocate has to be mentioned. Lastly, advocate's signature stating that he is accepting the Vakalatnama should be present. Next, let us understand when Vakalatnama is not required. The Allahabad High Court in case of Baru Singh versus Baburam Sharma 1997 clarified that in order for an advocate to plead cases on behalf of his client, he has to file a Vakalatnama under Order 3, Rule 4 of CPC. However, the court also mentioned that Vakalatnama is not necessary for performing any legal task such as providing legal opinions, sending notices, drafting petitions, or preparing any other essential documents. Next, let us understand when does the validity of Vakalatnama ceases to exist. So the first one is when the client dies. Secondly, when the advocate dies. Thirdly, when there is withdrawal by the client. Fourth, when there is withdrawal by the advocate with the permission of the court. Lastly, when the case is concluded. Lastly, let us understand what are the common mistakes done when filling a Vakalatnama. So the Supreme Court gave details of this in the case Uday Shankar Triyar versus Ram Kalevar Prasad Singh 2006. So the common mistakes are as follow. First is they fail to mention the name of the person who is executing Vakalatnama by leaving it blank. Next, they fail to mention the name, designation or authority of the person executing the Vakalatnama on behalf of the grantor. Next, they forget to mention or the signature, mention the name or signature of pleader on whose behalf the Vakalatnama is executed. Next, they fail to mention the address of the pleader for the purpose of service. Next, they fail to mention the Vakalatnama is executed by someone for self and on behalf of someone else. Next, they fail to disclose it as executed by GPA holder, and also they forget to annex the copy of GPA. Next, they fail to mention serial numbers when multiple people sign a single Vakalatnama. And lastly, failure to mention when a pleader engaged by a client executes Vakalatnama in favor of other pleaders. So these are the scenarios which was observed by the Supreme Court. So one last information about Vakalatnama, guys. So Vakalatnama, it is usually affixed to the last page of a plaint or a suit, and it is kept with the court records. So that's it about Vakalatnama, guys. In case you like my video, please do like, share and subscribe to my channel for more such videos. Thank you.